Hi, I'm Mary Wing Soares, and I'm here again with another edition of It's Your Choice. Today I have very special guest host, Mark Oswald, and we're here to talk about the deliberative session, to explain what it is and the history of it, and to get some questions answered. So Mark, let me turn it over to you.
Thanks, Mary. With me today I have our Superintendent of Schools, Nate Greenberg. Welcome.
Good morning, Mark.
We have long-tenured School Board member Steve Young.
Hi, Mark. Thanks.
And our school moderator and attorney at law here in Londonderry, John Michaels.
Well, Mark.
Welcome. Oh, well, that wraps it up. Thank you. The intent and the purpose really behind this program, I think, is to help educate our fellow citizens in terms of the deliberative school meeting process. A little bit of the history, how we came to be at this point, and certainly we can touch on the litigation recently that came before the courts. So I think I'll start, John, with you. You've been school moderator for a number of years, and we don't have to go into ancient history because you're not that old, but around the deliberative session itself.
The deliberative session came into being the first time under SB 2, which is a law that the legislature passed probably in, I'm going to guess, late 90s. The school district adopted SB 2, I think it's probably in 1998, I think is the year. Prior to that, we had a lot of contentious issues in the school. I've been either moderator or assistant moderator since 1986. So during the period prior to when SB 2 came in, during the 10-year period, we would have groups somewhere between 600 and I think we got as high as the upper 1800s. We had years we were concerned about where we could meet. We had years we had meetings take place not only in the gym but in the middle school. And we would have contentious issues about do we cut the budget, do we not, do we build schools, do we not, and we had a very large group. We then, SB 2 came into the school district, and attendance dropped off into the low 100s a year or two. And the people were concerned that a small group of people, as opposed to the large numbers we had before, would be deciding major school issues. And let me explain what a deliberative session is and what it isn't. In a deliberative session, every article that the school board proposes is brought up and discussed. So we have 10 articles, everyone's brought up and discussed. Under SB 2, if we brought up an article, say, to build a new rec field for $500,000, under a deliberative session in the SB 2 way, somebody could gut that to $1. So in effect, a small group of people could knock out whatever you wanted to do. It's more a way to kill it. They could deal with the budget. They could go and say, you know, they could knock it by $4 million. Then whatever is done there goes to a vote by all the people. The concern at the time of the charter, and I was on the charter commission, the concern was that we didn't want 100 people or a small number to have a veto power over anything the school did. And the concern was not liberal, conservative, pro-school, anti-school. It was, you know, who knew what group would happen to show up what year? Because in the 10 years before, we had strong showings of every group you could think of. And so it was, how do we protect ourselves? And so the charter came up with this quorum. And what happens now is that under our school district deliberative session, every article comes in and is discussed, but you can't modify it unless we have a quorum. So if we have a discussion about doing a new field, that is, people can discuss it, they can discuss all sides, but nobody could come and gut the article. It has to go on the ballot and be voted on by the people. If this, at the next meeting, we have 500 people, and we had an article, spend $500,000. Somebody could come in and move to amend it to $1. And if that passes, effectively it's killed, and the larger group of voters never get a chance to vote on it. So that's a short version of what we have and sort of how we got there.
Let me back up and ask two quick questions. One, you alluded to the fact that in about 2000, the Londonderry School District established a charter commission.
Right.
You were one of
the members,
10 or 12
yeah,
members,
right.
And you studied, you researched, you met with other officials from other communities to see how they would govern, how the mechanics or the process would work. But even over and above that, the state requires a deliberative session, correct?
Well, no, I mean, we could go back to the old way that there's no deliberative session. The state
Right.
doesn't require a deliberative session. We, on the Charter Commission, decided we would do a blend of SB2.
Mm-hmm.
And we're not doing SB2, there's different provisions under the law.
Right.
But we decided as a commission that we wanted a large number of people to vote. So as opposed to voting actually at the meeting. In the old system, it was everything came up and everything got voted on right at the time.
Right.
But we typically had a large number of people there.
Mm-hmm.
The SB2, or not SB2, SB2 got it so that you're voting on election day and you typically have more people vote.
Mm-hmm.
Our particular charter provision has it that all these things get voted ultimately by the voters at a larger turnout. So we decided, the Charter Commission decided it wanted a form of deliberative session and it wanted everybody to vote, but it didn't want the meeting to be hijacked by one group or another.
So I'm not understanding, and I'm sorry to interject, but under SB2, you do not have to have a deliberative session?
No,
And so-
SB2 requires a deliberative session.
Okay.
But we could go under the old town meeting system, in which we were originally. Originally, we had a system, the school board or voters proposed certain ballot items. Those then went to a meeting, a school district meeting, where everybody discussed them. They could amend them, they could vote them up and down, they could change them. There are some parameters of what they could do. But it was, that meeting then dealt with everything.
Mm-hmm.
And we would have typically groups of 600 to 1,800 over the 10-year period before we put deliberative sessions in.
Okay. Now, Steve, I'll turn to you on this follow-up question. Historically, John touched on this, but say the last 5 or 10 years, we've been averaging how many people at a deliberative session?
Well, we get, I think the most we've ever had has been around 300 people. On the average, we probably run 60 people, maybe 70, and that's if the spouses of the school board come. It tends to be pretty light in attendance, but I think the reason for that is people are happy with the way it is. Mm-hmm. The candidates forum, I'm often asked the question, as I was today, who's the incumbent by citizens? And I have to ask why. Why do you care who the incumbent is? And it typically is because they're happy the way it is. Mm-hmm. And I think that's the reason people don't show up at this meeting. I think, John, though, I have a question for him, because as I understand it, back at the Charter Commission, it was an extremely diverse group.
Absolutely.
When I read that list, I would never expect to see them in one room, let alone at the same table.
A year's worth of meetings, no less. Right?
And their concerns, or the reason for their quorum, was on both sides. It was, they were afraid that it would get cut, and they were afraid that the teachers would come in and increase it.
Right. It was, the real interesting thing is that in hindsight, people look and said, oh, it must have been one side or the other pushing the equation. It wasn't one side or the other. It was a genuine concern that any of about 4 types of groups could really, change the thing some way,
So to Steve's point, you had this very diverse representation of the community.
Yep.
And the consensus of that group that the voters then subsequently approved was they wanted kind of a fail-safe.
And that group was unanimous.
And it was unanimous in it, and we had a lot of discussions about it. We asked council to go and look. We looked at other places. Very few towns had ever done a charter, so we didn't have a lot of ground to go on. But we knew on one side, if you were like a city, the school board would have voted everything in. And if you were more like the old town meeting, the voters would have voted anything. And the statute said, you know, you want home rule, you want to do something in the middle, you know, go for it. And when we sent the stuff up to the Attorney General's office and everywhere else, I mean, nobody came and said this isn't right. Nobody said you can't do it. And at the time that we were doing the charter, there were surrounding communities who just did SB2, and there were turnouts of 10 people, 12 people in big communities. And so a real fear was that some group was going to thwart the wishes.
The Assistant Secretary of State said it this summer. I was on the Town Charter Commission, and this summer when the Assistant Secretary of State spoke to us, he said just that. He said one of the problems is when you go to an SB2 style form of government, and by the way, we are not SB2 style, we are a charter form of government, but when you go to that form of government, when you have a deliberative session, that eventually the attendance will decrease. People won't come. And he said at that point, and this is his quote, at that point, people tend to create mischief. And they make alterations to the budget. And I think that's what this group of diverse people 10 years ago, why they made that decision.
Now there was an initiative or an attempted movement a year or two ago to reduce the quorum from 500 to I think 300 or 350.
It actually has happened in addition to the original quorum vote. There have been two other votes that the voters have taken, and there have one in between that. There was also a move to change the quorum number, and it was to change it to it wasn't 350.
It was 4%, right?
It was changed. It
we
always had been 5%. It always was 500 and a percentage, and we lowered the percentage as the number of voters increased.
Right. Before that happened, though, at the deliberative session, I can remember it failed 3-2. There was also another attempt to reduce it, and I think it might have even been to the 350. So 2 years ago, Ron and I, we just voted on this last year. Ron and I presented to the voters the concept of going to 350 and eliminating the percentage altogether. And that was supported by the school board 3-2, so the board was split on making that change. The others on the board didn't want it to be reduced.
So the school district now, with this charter, has operated successfully for about 10 years, 11 years, with this quorum, 500 in place. There's been really no opposition or controversy or whatever until just the past several months. So I'd ask the superintendent to kind of bring viewers up to speed in terms of there were a number of citizens that stepped up, 3 I think.
Sure. Yeah, this actually goes back to last August when the Town Charter Commission asked for an opinion from first the town attorney and then from the state attorney general as to the validity of a quorum requirement regarding the town, not the school, but the town. The Attorney General came back with his opinion saying that he didn't believe quorum was appropriate for the town based on what they had said. That then germinated over to the school side where people began saying, well, if it's quote unquote not permissible on the town side, then why is it permissible on the school side? We contacted our attorney, and we had a number of discussions at the school board level. Our attorney is in firm belief that under the home rule provision that the charter as it exists now is perfectly legal, being one with a quorum. We also feel, based on the fact that, as was mentioned before, that the Secretary of State, the Attorney General's office, and the DRA had over the last 10 years 3 opportunities to review the charter and 3 times basically gave it its blessing, was perfectly legal. Then as we went through, there were questions raised, well, why can't you just find out and ask for a declaratory judgment? The board said, okay, we will get an opinion on that. The opinion we got back from our attorney was that, in fact, the school board could not file for a declaratory judgment based on a ruling in a Derry case about 7-8 years ago, that there had to be someone who was, it's not the legal term, was offended aggrieved by the action.
That is the legal term.
Right.
Yeah, we have a lawyer here, so this is good. This is good.
the legal term, yeah.
Okay, there we go. So the school board, in effect, said, okay, we can't ask for a declaratory judgment. The school board did say at a meeting, here's a process that people go through to file a petition to adjust the charter if you so wish. People elected not to do that. There were 3 citizens in town filed a suit then asking for a preliminary injunction.
But there's once, before they filed that, they sent me a letter.
Right.
And they asked me to tell them whether I would enforce the quorum requirement at this year's meeting. And I wrote them back and said, I'm the moderator, I have to follow the charter and the law. And I said, you know, whether I think it's a right or a wrong thing is absolutely immaterial. And I said, I will follow the charter and the law.
Right. And so the 3 individuals then filed suit. And the school district obviously was the defendant in the case, and we went before Judge Nato to defend the school district's position. Judge Nato's ruling was as follows. A preliminary injunction is a provisional remedy that preserves the status quo pending a final determination of the case on its merits. The burden is on the party seeking the injunction to show likely success on the merits. The issuance of a preliminary injunction is an extraordinary measure and should not be granted unless there is an immediate danger of irreparable harm to the party seeking injunctive relief and there is no adequate remedy at law. Thus, the well-established standard of granting injunctive relief may be summarized as requiring the petitioner to demonstrate that 1, he or she is likely to succeed on the merits, 2, there is a present threat based upon a lack of an adequate alternative remedy of law of irreparable harm to the petitioner if the court does not grant injunctive relief, 3, the potential harm to the petitioner outweighs any harm to the party or parties who should be enjoined, and 4, the public interest would be served by granting the injunction. Judge Nato, in her decision, said the court finds that the petitioners have not provided information sufficient to warrant the grant of this extraordinary measure, as they failed to demonstrate that irreparable harm would result but for the grant of this preliminary injunction. Further, the purpose of a preliminary injunction is to preserve the status quo and enjoining the enforcement of the quorum provisions which have existed for 10 years would accomplish the opposite result. So she denied, basically what it came down to was the judge felt that based on the information that was provided in court, they had not proved their case, and therefore she was going to allow the school district, the deliberative session to continue as it had for the last 10 years. So she denied it. Then a question was raised internally by one of the school board members because he had been asked a couple of questions. Well, the injunction is in place. What happens at deliberative session? Can actions at deliberative session be turned over? I felt the answer was no, and I wanted to confirm it with our attorney, and he wrote back, the court has looked at the petitioner's request and refused to grant it on a preliminary basis. It is beyond my comprehension that after a court review, even if it is only preliminary, that a court would ever question the validity of a meeting held in accordance with the court's ruling, even if it later found the charter to be unlawful. So basically what he was saying, okay, and I was trying to think of an analogy, was that the judge ruled against the preliminary injunction, allowing the deliberative session to continue as it had for 10 years, and it's beyond his comprehension that she would allow it to occur and then later vacate any actions taken at the deliberative session. You know, unless Judge Nato had come to Londonderry and got a bag of Honeycrisp apples instead of Macintosh and was very upset and would decide later on that she was going to say you could have the meeting only, and was really ticked off because she got the wrong apples, would later vacate the action. It just doesn't make sense. So the position the board is in at this point in time, and the situation we're going to operate under, is we will move to deliberative session, which is on Friday, February 11th. And we will conduct that meeting. The moderator will conduct that meeting the way it has been conducted for the last 10 years under the charter. And actions there would be legally sound, and whatever actions occur at that point will then be placed on the ballot for the voters in March.
And if we have 500 people, they can
Correct.
amend it.
One of the questions I have been asked, and I'm sure John can answer this, is without quorum present, what would be a procedure on a particular article? And with a quorum present, what would be the procedure on a particular article?
We're going to take the articles up in the order that they're on the ballot. And
This is without a quorum.
this is no matter what we do.
Okay.
No matter what we do, we go through, Article 1, we bring it up, and we bring it up for a discussion. If we have no quorum, when the discussion ends, that's it, we move to the next article. If we have a quorum, the quorum has the ability to amend it if they feel they wish to amend it. They don't vote that anything happens to it, but they have the ability to amend it. So if we had a hypothetical, something that was $500,000, and somebody said, well, it should be 7, somebody would make an amendment, we'd discuss the amendment. If the amendment passed that it's 700,000, that's what would show up on the ballot. If they decide to cut it, that's what would show up on the ballot. So depending on whether you have 500 or not, it will show up. One of the things, prior to this, Mark and I had a little discussion, and I think there's some validity to it. People ask, why don't we have a quorum? And I think the reason that we do not have a quorum is that for the last 10 years, we have not had contentious issues. The budget hasn't been rising much. We haven't been building schools. I've been around this too long with the town and the school that I know when you get something contentious here, people will show up. I mean, there's no doubt in my mind that if something's contentious, we will have a crowd, whether it be a planning board meeting, and Mary's seen some of those. She keeps asking, will somebody please show up? But you get a contentious issue, you fill the room, and sometimes you can get hundreds of people. They will show up for contentious things. So I think one of the reasons we've never had a quorum is that a contentious issue, hasn't been there yet.
If you look at the level of excellence that our school system continues to attract new families to our community, you keep raising the bar. I mean, it's tough. I hate to use a sports analogy, but I will. I mean, it's a building process, and it takes time. And I think John makes a very valid point. The infrastructure is in probably as good a condition as I've seen the 24 years I've been a resident and taxpayer. The school board, to their credit, the administration, the superintendent, have made difficult decisions, but around budgetary issues of reducing staff as enrollment has seen some slight decreases. So I think there's been a very proactive approach on the part of the administration and the school board. And to your point, John, very well stated. If it's not an issue, people don't necessarily see the need to show up.
Yeah, if the school board proposed a 5% increase in the budget, and by the way, let's go and build something else new, I would, I saw that coming. I would say, we can't meet in the cafeteria, let's go and set up in the gymnasium, because I know we'd have a large crowd.
If graduation rates took a dive, or truancy went up.
Any of that stuff,
yeah.
I mean, we would have a huge crowd. There's no doubt in my mind.
John, let me ask you about the quorum, no quorum again.
Yeah.
So let's say that this year we do get a quorum,
Right.
and there's 500 people, and to make an amendment, what does the citizen have to do? Because they haven't seen it in 10 years.
Okay, what you have to do, and which I'd explained in the beginning of the meeting, if you wish to make an amendment, please put it in writing and give it to me and let me know about it. And then we will first discuss the article. And after the article is discussed, then I will accept the amendment. If there is a second to the, I'll read it. And if there is a second, then we will discuss the amendment. And we'll just, and if people, and at a point we'll go to a vote. If people decide they want to amend the article, we'll vote the amendment in. If they decide they don't, it will die. And then we'll continue a discussion on the article. And at some point I'll say, if there is no more discussion, this article is going to move on to the ballot. There is not a vote on the article as such. It goes on, but if we've amended it, it goes on as amended. And I will assist anybody in working amendments or going through.
So if they need help, they shouldn't be afraid to come up to the podium.
No. And Bob Sauer is going to be the assistant moderator there, and Bob's been doing this for a while. Bob or I, will gladly go and help anybody write it up so it, it makes sense as to what they want.
So you'll point out when you start the meeting to help
I'll point
people.
out to it, and I'll say if anybody has an amendment, please come up, see Bob or see me, and we'll help you. And we'll help you through the procedure, and we'll discuss what it is. Because we know people don't know what their
Mark,
procedure.
so now if I could talk about what happens if there isn't a quorum.
Right.
And I'll talk about the last two meetings. I'll go 2 years ago. 2 years ago, I considered between the time period of when we moved it to the deliberative session and we held that, I made the decision that the school district, in my opinion, needed to cut some more money. And I was interested in seeing that in personnel. Just tell everyone, I didn't blindside the superintendent. I talked to him ahead of time and told him I was looking at doing this. So I made a motion in the meeting, and what I did, because there wasn't a quorum, as a school board member, I gave a written question to John, my motion, before the meeting started. And it was simply to decrease the budget $300,000 and to do it with personnel cuts. It ultimately failed. The board didn't support it. It failed. 2 of us voted in favor and 3 against. So that didn't move on. And then there was another school board member had a similar motion, and that one also failed at a 3-2. So if there isn't a quorum, the board can actually make
That's
changes.
one thing we should go, is that there is a provision, again, another safety valve for things that happen between when the board sets it up and when it goes before us. And the way the charter says, if the school board, prior to us going through the articles, votes an amendment to an article, that amendment will be. So let's hypothetically take our 500,000 for something or other. Okay,
We're still going to build that field. I mean, you keep bringing it up.
Whatever it is. But let's suppose that was there, and
Right.
let's suppose they had gotten some architecture or contractor information in, and they said it's not 500, it's 4. Before we start, the school board can vote a change. So we start the meeting. Somebody on the school board says, I believe we should amend Article umpty-ump, and they do. And the school board is the one that votes it in. And it's their decision to vote it in. And that's provided in the charter. And that, again, was one of those things which the Charter Commission put in sort of, we got most way through, and somebody said, geez, the federal government, the state, they're forever doing stuff, blindsiding us. We have to have some way to make it a change. And more often it was, during that period of time, it was that the legislature couldn't decide what to do with school funding, and so we allowed a procedure for the school board to go and change it. Now, I think what we envisioned is not what really happened. What we envisioned was the school board would meet before the meeting, come up and say, yep, we should add this, and they just do it. But what's happened, there's nothing, it has to happen before we take up any articles, and when it has happened, they've tended to, in effect, had the meeting right there.
It happened last year where a citizen came to the microphone and said, and asked the school board, because we were the only ones, there was no quorum, so we were the only ones that could make a change, not to get into the complexity of doing it before the articles read and not, but the person wanted the school board to decrease the budget $1 million, simple as that. And she stood at the microphone and said, I'd like the school board to cut the budget $1 million. And in this particular case, the school board, we looked at each other, but took absolutely no action.
So I think what we all have to remember here is that we have elected the 5 people that are on the school board to represent us. And we are trusting the fact that you've gone through all of this budget hearing process. We have that opportunity to express our opinion to you. And I have seen evidence that you listen to the citizens, because I've seen changes that are made during that budget process. You get to the deliberative session. At that point, if there isn't a quorum, it's up to the 5 of you again. So my point is, we've elected you to represent us. We have trusted you that you're going to make the right decision. Otherwise, we vote against you.
Sure.
All right?
I mean, I know it's basic government history and action, but this is not a democracy. It is a democratic republic.
Right.
And that is how the school board functions. And if it isn't working, just like they'll show up at a deliberative session if we do something stupid. If we do something stupid, they'll kick us out of office too.
So I mean, I think that's the recourse at that point.
I want to go back to the superintendent. So the judge gave a ruling on the motion for a preliminary injunction.
Correct.
Denied it, gave case law and so forth. Where's that at from a taxpayer standpoint? What has that cost us in holding our position or defending our position?
Right. If you go back to July, when we first contacted our attorney to get legal opinions up until yesterday, total legal cost was $17,800. All told, the court case in specific was pretty close to $10,000. The money prior to that was for the additional research and responding to questions and doing some research on the statutes. So the total bill has been $17,800 right in that area.
And then the cost, the indirect cost, would be time that you, the school board, the moderator,
Yes.
others have had to dedicate or devote
That's correct.
to defending a established process of some 10 or 11 years.
That's correct.
And is there a way to recoup that $17,000?
Well, in our filing, we asked for recovery of attorney's fees.
And that's, and I'll turn to our legal counsel here. In New Hampshire, that's a customary practice? I mean,
A customary to ask,
Yeah.
not too customary to ever get it.
Right.
okay.
I would, it has to be almost a complete abusive process to get it. If there are some legitimate issues, the court is very unlikely to grant the payment of legal fees.
Well, it's not going to cost us any more to ask for it, right?
That's right.
We've already,
No.
We've already had to spend it.
It's generally asked for.
Yeah, it's
Right, but I'm sure that the reason that it's not automatic that you get that is because that would discourage people from ever questioning their government.
Correct.
And of course, we want people to question us, but it's the method of how they question us
Right.
is what our
Right.
concern is here.
absolutely.
Okay. Any final thoughts? Mary, you're active in the community. You've served on the planning board. You're a taxpayer. You're an educator. What's the talk around town? What have you heard as you've performed your functions?
Well, I'm hearing a lot of buzz about people coming to the deliberative session for the first time in a lot of years, and that's good. We do want to see people come, but I would agree that you know, I would agree that people are happy with the schools the way that they're being run. I think they look at the superintendent and the school board and they see him react and them react to schools increasing and schools numbers decreasing. But I also think that we shouldn't just be happy because they are happy and they don't come and tell us. We need people to come and let us know the positives and the negatives. You know, I'm a teacher, and if I don't compliment my students, then they're not going to be good anymore. They're going to get complacent, and they're going to, you know, they're going to fall back. And that's not what we want our school system to do. We want our school system to stay excellent. The only way that happens is by people giving us information, giving us feedback, whether it be positive or negative. So I would encourage everyone to come to the deliberative session on February 11th at 7 o'clock and express your opinion. Even if you're not able to vote, you know, make an amendment, you are able to express your opinion. The moderator does allow comments to be made, and the school board does listen. That's
and
my
we
soapbox.
would encourage viewers, 7 o'clock, high school cafeteria, Friday, February 11th, to attend and participate in the process.
Babysitting.
And there will be babysitting available. Members of our Student Council and National Honor Society will provide babysitting services for anyone that's interested. Lion King is being shown, and 3 rooms will also have arts and crafts. So
Voters can't go to
I was just going to say, I'm thinking about it.
Or school board members.
If they serve popcorn, I'm there. You know,
There you go.
The only flaw in this whole plan is that we have an excellent drama production going on the same night.
Right.
So I thought what you should do is tell all the audience that they have to come from 7 to 8 to the deliberative session, and then they can go see the play.
There you go.
Okay? But in any case, all of you who are buying tickets for Thursday and Saturday night, come to the deliberative session on Friday. And thank you very much for being here today.
Thank you.
Mark, thanks for hosting. And
My pleasure.
this is Mary Wing Soares, and you've been watching It's Your Choice.